Hi everyone, and welcome to today's webinar titled COVID-19 When a Party Cannot Meet Its Contract Obligations. My name is Alex Majeure, and on behalf of everyone at LexisNexis, I wanted to take this opportunity to thank each and every one of you for taking the time out and engaging with this webinar, especially during these unprecedented times. Our speaker today, who will be leading this webinar, is Dudley Kneller, partner at Gadens. Hi Dudley, how are you?
Good, thanks Alex. And yourself?
Pretty good during these very interesting times.
Yeah, very interesting indeed.
So look, just for those who don't know, Dudley Kneller is a technology lawyer with a specialty in privacy, cyber risk, and strategic sourcing and supply projects. He has more than 20 years experience practicing across Australia, Europe, and the UK, and has worked on projects based in a range of countries, including the Philippines, India, Russia, and throughout South America. Dudley is listed in Best Lawyers in Australia for Information Technology Law 2020. He's also listed as one of a group of recommended technology, media, telecommunications lawyers in Melbourne in Doyle's Guide from 2015 to 2019. And on that note, I'll hand you over to Dudley, who will begin the webinar.
Thanks very much, Alex, and hello everyone. Thanks for joining us to talk today about when a party cannot meet its contract obligations, with specific reference to the current outbreak of COVID-19, which is causing all sorts of challenges. And I don't want to use the phrase over and over again, but we are in unprecedented times. The COVID-19 pandemic has, I guess, ushered in an extraordinary challenge to both Australia and global businesses at a personal level, at a public health level, and also at a business level. We're seeing the state and federal governments responding on almost a day-by-day basis, and that response continues to evolve as our governments in some ways struggle to understand the virus and to take steps to control the spread of the virus. What does that mean from a business perspective? Well, clearly there's huge disruptions that we're seeing in supply chains. We're seeing parties that are unable to obtain the supply of product or service. We're seeing suppliers who are frustrated in their attempts to meet their own contractual obligations. What I'd like to do today is just talk a little bit about what happens when you or one of your suppliers is unable to deliver on its contract obligations. It might be that your supply chain is in lockdown overseas, and you're no longer receiving goods to deliver to your Australian customers. It might be that you've got a components manufacturer that needs to deliver replacement parts to you, and their equipment is out of action, and or logistically they're not able to deliver that to you. It might be that you're reliant on a subcontractor or another third party to assist with performing the supply, and they may not be able to perform themselves, so that puts your obligations at risk. These are all real scenarios. These are happening as we speak, and we're seeing a number of Australian businesses really challenged to address and work through those delays, those incidents that are preventing them from meeting their obligations. So today's session is really about talking a little bit about what parties can do to mitigate against such incidents. How do you protect your business in the event that you have a claim against you for non-delivery? And on the flip side too, how do you mitigate your risk if your suppliers are not able to deliver product or service to you? So let's just jump in. Okay, so many of you would have heard of the term force majeure, and many of you will have contracts in place with a force majeure clause. Force majeure clauses often sit at the back of the contract in the general terms. They're not often called upon. The parties typically are more interested in dealing with the primary supply obligations, making sure they manage IP properly, dealing with confidential information, and allowing for appropriate termination rights, and obviously focusing on the underlying commercials of a contract. So force majeure clauses don't often get talked about very much, and obviously they're being talked about a lot more now. It's helpful, I think, just to briefly outline what force majeure clauses do and when they can be used and what protection they can offer. Once triggered, a force majeure clause will allow the affected party to be relieved from its obligation to perform, or it may extend that time frame for performance of that particular obligation. Often when you read through a force majeure clause, you'll see a list of triggering events. Triggering events are the acts of God type events: earthquakes, storms, flood, lightning strikes, war, terrorism, riot, sometimes industrial action. What's often missing, and certainly there are some examples of force majeure triggering events that include epidemics, but pandemic is not necessarily a phrase that you will often see as a triggering event. We'll talk a little bit more about that in due course. The other triggering events that you might see from a force majeure perspective are, I guess, a catch-all provision. So it'll be a phrase along the lines of, any causes beyond the reasonable control of a party. In terms of some of the basic requirements, force majeure events are required to be outside the reasonable control of a party claiming that the incident has occurred. So it can't be something that's within their control to manage. So again, examples of supply chains being disrupted due to earthquake, a storm, a flood, etc., where that has an impact on a party's obligation to perform, and it's clearly a matter that's outside their reasonable control. That's an incident that that party can put their hand up and say, I'm calling force majeure here, I'd like to invoke that clause. You'll see some clauses are fairly short and sweet, but others are a little bit longer. Sometimes there are additional requirements negotiated between the parties. Often there'll be various exclusions for acts or omissions of subcontractors, customers taking the view that the supplier should be able to monitor and manage its own subcontractors. There'll be obligations on the affected party to take reasonable steps to mitigate against the actual event. That has to be viewed with a commercial lens, so something that a party can do to reasonably mitigate or reduce the impact of the event. Certainly that's appropriate, but obviously you have to draw a line somewhere, and at some point it needs, if it becomes uncommercial, just not technically feasible, then obviously that obligation would reduce at that point. Force majeure clauses are typically read and construed against the party seeking to rely upon them, so they'll be scrutinised from that perspective. From a supplier perspective, and we will talk a little bit about suppliers and customers and their different perspectives, but from a supplier perspective, having a longer or more comprehensive triggering list or list of triggering events will assist you to claim the benefit of a force majeure incident. The flip side is also true. So customers will often seek to have a narrow scope of triggering events, and again reduce the scope of when those force majeure incidents can be triggered. When the event or when the force majeure event is triggered, the party's obligations under the contract are suspended until the force majeure event ceases. Most clauses will provide that if the force majeure event is not resolved within a certain period of time, that can be anything from 20 days to 60 days or 90 days, again, depending on the type of contract, then the parties will have a right to terminate or perhaps agree some sort of variation. Sometimes that's mutual, sometimes it's one-sided. the parties will need to consider any knock-on effects to other provisions of the contract in that situation. So in some cases, the parties may have agree that the suspension or the suspended period will be added to the end of the existing term of the contract. We've talked a little bit about force majeure clauses, and as you can tell from our discussion, force majeure clauses are clauses that are included in a contract. So they arise as a contractual arrangement between the parties. They're included as part of that commercial dealing. In the event that your contract doesn't contain a force majeure, it's important to understand whether there are other areas of law that can step in and assist you in that situation. Now, I don't want to talk a whole lot about the law of frustration. It is a very narrow area of law, but it's also relevant in the context of what we're talking about today. Force majeure should be distinguished from the common law doctrine of frustration. Frustration is a situation which will relieve the parties to a contract if there's been some intervening or supervening event which is beyond the control of the parties, and it results in a radical change in the circumstances in which a contract is to be performed. It's important to remember that force majeure is not a common law doctrine, but rather a commercial construct. Frustration, on the other hand, operates differently. It will bring a contract to an end. In terms of, I guess, some of the important elements, frustration results in a contract being ended where an intervening or post-contract event has occurred and it's been through no fault of the parties. It makes the performance of the contract obligations impossible, or it transforms the obligation into something that's completely different and certainly beyond the original intent of the parties. The reality is that frustration is typically not easy to establish and has a very narrow scope. Also importantly, a contract will generally not be frustrated if it has if the contract already has a force majeure clause in it, which can deal with that sort of issue. There are various cases around the place. There is a 2004 Hong Kong case that deals with the SARS epidemic, which is obviously relevant in the circumstances. In that case, a tenant was required to isolate for a 10-day period due to SARS, and was at the point, I think, 13 months into a 24-month commercial lease. The tenant put their hand up and said, "Hey, look, this sounds like frustration to me, and I'd like to discharge the lease." The court at the time rejected that argument and pointed to the fact that the isolation order was only for a very short period of time in the context of the entire lease. In some ways, a force majeure clause may have been more helpful to him. Interestingly, in the COVID-19 situation, the longer we are in this period of isolation, the more likely that a party may be able to rely on frustration. But our advice is obviously have a comprehensive and detailed force majeure clause in there to deal with that. We talked a little bit about suppliers and customers as well. I do want to talk, I guess, from a practical perspective and some tips moving forward, and you'll see some overlap and hopefully not double up between these two themes. From a supplier perspective, the first port of call will be what does your contract say? Does it have a force majeure clause? When is it that you can trigger that force majeure incident? What does it mean when you do trigger it? I think in the environment that we're in at the moment, we're encouraging parties to have the conversation with their partners, their customers, their suppliers very early, and talking about other alternative forms of supply or delivery. So what else is commercially feasible? Are there workarounds within the existing obligation? Be on the front foot with your customer early, and look to see if you can renegotiate that obligation in a different way, so you can perform the supply, but in a different way. From a customer perspective, again, being clear about which material contracts you have in place that may be impacted. That's a process you should be going through now. Understanding of those material contracts which have force majeure clauses. How do those force majeure clauses work? Understanding your rights and obligations, and obviously the rights that you can impose on your suppliers. Again, communication is key. Have the conversation with your key suppliers early. Understand what is the business impact if they're unable to deliver product or service to your business. Understand and discuss alternative forms of supply. You know, what is the plan B in that situation? Are there alternative suppliers? Are there alternative products or service that can step in and mitigate the incident from your perspective? You'll see there I've got the obligation around termination rights. Termination is the big stick that should always be in your contract. And so if push comes to shove and there's really no further options available to you as a customer, then you can invoke that right to terminate. Again, it's important that you understand how termination works and the impact of invoking a termination right. If you terminate too early or not in accordance with your contract, then you do leave yourself open to repudiation by your supplier. And I think in this environment, being very mindful that commercially, is a termination remedy all that helpful from your perspective? At the end of the day, you're probably more interested in continuity of service and product delivery as the priority. So the priority from your perspective will be to work very closely with your supplier to see what's possible, to understand whether they can obtain some alternative form of supply. So coming in hot and heavy and threatening termination perhaps may not progress that conversation as well as you would like, and you may end up in a situation of not having the supply and terminating a contract that you may otherwise have been able to vary properly. Okay, moving forward in the current environment, what we're seeing is, I guess, is a flurry of activity. We're seeing a flurry of activity as partners look to their key contracts and understand where the risk is, where there's current delay in delivery, where there are issues around supply chain that are going to prevent you from performing your obligations. So we're seeing suppliers and customers already looking to rework contracts to provide for greater flexibility. For those of you who are entering into new engagements, the number one request at the moment is, can you please include pandemic or similar wording in it as a triggering event? So the parties are obviously in an environment where COVID-19 is preventing or delaying delivery or supply of product or service, and are wanting to include that as a specific force majeure event. I don't propose to get into the discussion in too much detail, but there will be some discussions around whether a foreseeable event such as COVID-19 means that can even be included as a force majeure event. On the supplier side, we're expecting and certainly being requested to include additional reporting obligations, including business continuity planning obligations and similar requirements to support customers in the event that a force majeure event is called. Some contracts are, and suppliers, sorry, and customers particularly, are looking to include specific step-in rights. So if a force majeure event does occur, the customer has the right to step in and appoint a new supplier, or to take over supply obligations themselves if they can more effectively discharge them. Also, we are seeing stronger termination options being requested, and I think that the big theme is these obligations are being triggered a lot more quickly. So parties are saying we want to be able to call force majeure and make a very quick call as to the impact on service, and invoke that clause very quickly. And if we need to move quickly to terminate, then we can do that. From a supplier perspective, and we haven't talked about it up to this point, but typically usually there's a carve out in relation to payment obligations. So in other words, a force majeure event doesn't relieve a party from liability for a payment obligation. And that's important from a supplier perspective, so that COVID-19 or some other force majeure event is not used as a lever to refuse payment. That's pretty much it for this short presentation on COVID-19 and the impact to supply and delivery. We would encourage you to engage in your material contract review activities early to ensure that you're not caught out. Understanding your key legal and commercial arrangements and addressing supply and delivery risk at this point of time is critical. Review that force majeure clause. If you don't have a force majeure clause in your standard contract, look to include one and make sure it expressly deals with pandemics, and also that it expressly deals with foreseeable events given the environment that we're in. Taking the time to address these risks now will allow your organisation to move through the environment that we're in with COVID-19 with a reduced level of disruption. Thanks for your time, and happy to take some questions.
Excellent. Thanks, Dudley. And thank you for taking us through that. That was most helpful, especially during this environment. And look, I will take you up on your offer and ask a few questions, if I may. The first question is, what happens if the parties cannot reach agreement on a force majeure incident?
Yeah, look, it's a good question, Alex. The first port of call really is to see whether or not the contract provides for a force majeure clause. So I'm assuming that there's a force majeure clause and that the parties are in discussion around how that's working. Typically, there will be a disputes clause within the contract. So at some point, if the parties are unable to reach agreement, then the disputes clause would be triggered, and the parties would go through that disputes process. Obviously, it's in the interest of both parties to work collaboratively and effectively up to that point, because in some ways we're all in the same boat. We're all struggling to discharge our contract obligations at times in this environment. So certainly we'd be encouraging people to work collaboratively at this point.
Okay, so if the contract doesn't have a force majeure clause and it hasn't been frustrated, what are my options to resolve delays in delivery?
Your legal options sort of have not reduced entirely, but certainly they're not the typical options that you would go to. So they become commercial options. We talked a little bit in the presentation about the importance of collaborating with your partners early. So it becomes a commercial conversation. Engage with those partners early. Be creative about what outcomes you negotiate. We're seeing lots of creative solutions being provided, alternative forms of supply and delivery for product and service. Parties that are prepared to be more flexible than they perhaps otherwise would in a normal commercial environment. And I think, and we haven't talked about this at all, but I think keeping a very close eye on what level of government support is going to be provided to your industry by the Commonwealth and state governments. You will notice a theme with some of the recent announcements from Scott Morrison and Frydenberg as well, that a lot of the support is tied to cooperation and collaboration. So if parties are working well together and take advantage of government support for that particular industry or business that they're in, that support will be made available to them. It's where they choose not to be cooperative or collaborative, that the support will not be provided or will be withdrawn in some way. So that's something to bear in mind in terms of those commercial discussions that are going on at the moment.
Excellent. And just lastly, I understand that if an event is foreseeable, then it can't really be a force majeure event. Can you please explain this, having regard to the coronavirus, which is likely to delay future supply obligations? Can it really be included as a force majeure event?
Oh, look, that's a great question, and certainly it's a question that we've been asked in recent times. The reality is around foreseeability that there are a couple of schools of thought. There are cases that support incidents that have been successfully called force majeure events that were foreseeable, and there are also cases that are 180 degrees from that, where foreseeable events were excluded as force majeure events. What does that mean in terms of COVID-19? The reality is, if you want to include a foreseeable event in your contract arrangements, you need to expressly include that. You need to deal with it up front in the contract and be clear that you intend that a foreseeable event is to be properly considered a force majeure event if it meets all the requirements of the rest of the clause. So be upfront, be express, make sure you are very clear about including that within your contract, or as the case may be, that you're expressly excluding it from your contract.
Excellent. Look, Dudley, thank you so much for your time. I know it's a busy period, and we do live in interesting times. That was so informative, and we really appreciate it. And we look forward to speaking to you at the next webinar and beyond. And we wish you all at Gadens and all the attendees and viewers all the very best. Thank you so much for your time.
Many thanks, Alex, and to you.
Cheers.